The Juneau World Affairs Council and Veterans for Peace Chapter 100, in collaboration with KTOO, present the 2025 Juneau World Affairs Forum, Unratified, the International Law of the Sea Treaties, and their potential for protecting Arctic resources and cultures. In this lecture, The Extended Continental Shelf, Dr. Betsy Baker will discuss mapping the extended continental shelf underlying the Bering Sea and Arctic waters. Baker is an international lawyer based in Alaska and most recently former director of the North Pacific Research Board.
Thank you and good afternoon, and thanks to our two sponsors and also to the audience for the great questions so far, and to the speakers who've done all my work for me, right? So you're familiar with a lot of the issues underlying the shelf. So I'm hoping I can spend even less time on my remarks and get to continue the discussion we've had with Stephen Groves and with others. I'm grateful that the more than 2 decades of work by US government scientists, diplomats, and lawyers to map and describe the extent of our existing continental shelf rights are back in the news as our national focus turns to energy and mineral security. I'm also grateful for the opportunity to have spent 2 summers as part of the science crew in the Arctic on the US icebreaker, the Healy. That was way back in 08 and 09, and is pictured here with the Canadian icebreaker, the Louis S. Saint Laurent, on a joint mapping cruise. Somewhere in the back vessel, I'm standing watch with Larry Mayer of the University of New Hampshire's Center for Coastal and Ocean Mapping, who was the chief scientist for all of the State Department mapping around the United States. Many of the slides you will see in the next 25 minutes or so are from CCOM. That time at sea and my subsequent year at the State Department as a visiting scholar supporting the US Extended Continental Shelf Task Force form the basis of my remarks today, but my presentation represents my views alone and not those of the US government. Our 3 topics are listed there. What about the US Arctic Extended Continental Shelf in Alaska, other Arctic states, ECS, and then touch on seabed mining in the Arctic. And one that's not on the slide, but that I would like to raise is what we'll hear about tomorrow, which is the new agreement on biodiversity beyond national jurisdiction. As mentioned in some of the questions, the UNCLOS, and thank you to Jim for his introduction, is the umbrella agreement for a number of other agreements. Somebody already mentioned the fisheries agreement to which the US is party. The biodiversity beyond national jurisdiction we will talk about in great detail tomorrow, but that's another agreement under the umbrella of the Law of the Sea Convention. And I mention it because of the tiny little person on the first slide that we've seen at all the introductions in that umiak. And we have not yet talked about indigenous rights and interests and cultures and resources because UNCLOS itself does not mention them. But as we've added each new agreement under UNCLOS, we have worked toward acknowledging things that have developed over time since 1982 when it was signed. And that includes greater environmental protections, although those were mentioned in the original UNCLOS, but issues such as increased indigenous knowledge and rights and participation in things like the UN Declaration on the Rights of Indigenous Peoples, which did not exist in 1982. So it's a footnote, but I think it helps us understand the broader issues at hand. So with that, I'll move in, and I use notes so that I don't talk too long. In December 2023, as we've already heard, the US ECS project published an executive summary, this is the cover page, of information documenting the limits of the US continental shelf across multiple regions. The ECS project is an interagency body of the US government led by the Department of State. This 2023 milestone capped nearly 2 decades of scientific, diplomatic, and legal teamwork between government, academic, and other experts, at times in cooperation with coastal states, others on the Arctic, such as the Canadian-US joint cruise that you saw on my opening slide. We were both mapping our respective continental shelves. Indeed, when the 5 Arctic Ocean coastal states were actively planning and starting to collect data regarding their respective shelf entitlements, experts from all 5 of those states, including Russia, would meet regularly to exchange scientific, legal, and other information. This is the map that's in that 2023 publication. And while our focus is on the Arctic and the Bering Sea today, those 2 red arrows, remember that we also have ECS in the Atlantic, the Gulf of Mexico, Pacific, the Mariana Islands, and the Western Pacific. There was a lot of work that went into this. I think one of our questioners already mentioned the fact how large the shelf is off of the Arctic and in the Bering Sea. And in the Arctic alone, we mapped bathymetry of 520,000 square kilometers. That's a lot of bathy. And why are we doing bathymetric? So Jim mentioned that the requirements of the Law of the Sea Convention about measuring the extent of your continental shelf say you have to show evidence of what the shape, the geomorphology of the shelf is beyond 200 nautical miles. And multi-beam bathymetry helps us do that in a very sophisticated way. You also have to show the depth of sediment in part of what you're measuring above the ocean floor. And that's where the seismic comes in. So both of those, and you can see the number of track lines there that have been mapped. This was the largest mapping effort ever in US history. So this is, I know we're going to talk about the Bering and the Arctic, but a little closer to home, you have the Gulf of Alaska up there, and you can see the bathymetric, or some of the coloring there showing where we have new multi-beam bathymetry because the US has been mapping for the continental shelf. And this is what we knew before the multi-beam mapping. This was from single beam. We had a rough sense of what was out there. But with the multi-beam as bathymetric mapping that we did as part of the ECS project, we learned a great deal about what is off that part of the coast of Alaska. It revealed a lot of detail, underground rivers, more detailed information on known fish habitat, navigation channels and hazards for starters. There's just a lot of detail out there that we now have that isn't necessarily even going to be useful for the actual extent of the shelf, but we understand more about what is in the area that has been mapped, more about the potential resources. These are pockmarks at 1,600 feet, and we assume that there's some sort of methane or other gas bubbling up out of there. We could spend a lot of time talking about all of these discoveries. Gas hydrates in the Arctic, methane plumes off of California. So this is just to give you a sense of some of the information that was collected over the almost 20 years that we've been mapping and defining the limit of the shelf's extent. So why do states map? Remember, coastal states around the world are engaged in the process. They do so to show the extent of what are their inherent and exclusive sovereign rights in the continental shelf. Exclusive sovereign rights do not equate to full ownership, but rather to the ability to control who accesses the state's shelf and its resources, both living and non-living. These rights are not dependent on any proclamation. They exist ab initio and inherently, but other states need to know precisely where the limits of another state's shelf is if those rights are to be recognized. That precision of location provides legal certainty, which can help to clarify jurisdiction, resolve maritime boundaries, distinguish a state's extended continental shelf from the international area beyond national jurisdiction, which is managed, as we have heard, by the International Seabed Authority under UNCLOS. If you and other states know exactly where your ECS is, you can better manage it for use and conservation. And here we're going to get into some of the weeds, so bear with me. What and how states must map is spelled out in Article 76 of UNCLOS. It contains detailed and specific rules for determining the extent of the shelf, all of which the U.S. has followed to a T in its mapping. Article 76 has what we call customary law status and binds parties to the convention and non-parties alike. The coastal states' continental shelf is the seabed and subsoil of the submarine areas that extend throughout the natural prolongation of its land territory to the outer edge of the continental margin, or to 200 nautical miles from the baseline. And here we finally have a slide that goes into the detail of all of the zones that Jim helpfully described to us. I'm not going to walk through each of them, but the key distinction between zones shown here is between sovereignty, full sovereignty on land, and sovereign rights. On land and in the territorial sea, the state has full sovereignty or ownership. Up to 200 nautical miles from the coast, the state, or from the baselines, the state exercises sovereign rights, which is different than sovereignty, in two different ways. In the water column, known as the EEZ, and on the shelf, which is a separate regime. Beyond 200 nautical miles, the ECS, those sovereign rights are only in the seabed and the subsoil and its resources, not in the water column. So the EEZ is an entirely separate regime. With its 2023 publication, the United States joined the 4 other Arctic coastal states in indicating publicly the limits of their extended continental shelves. So this is a test. What are the other 4? If you start in the upper left-hand corner, that's the United States and the Beaufort Sea, and you work your way clockwise. Russia is about the entire half of the map that you see there. Then down to Norway, which the names are not very clear on the map. Then over to Denmark because of Greenland, and to Canada. This is, if you've seen me give a talk before, you've seen this map. I love this map. This is the International Bathymetric Chart of the Arctic Ocean. It is international, and it is a product of Article 76. When UNCLOS was signed, states started planning for demonstrating the extent of their respective shelves. They agreed to share bathymetric data to create this map, and they continue to update it. This is a somewhat older version. And the data is useful for much more than applying Article 76. Second, Russia, as we've heard already, has far and away the largest continental shelf, some 51% of the Arctic shelf. So yes, their submission is far-reaching because their shelf is enormous. Third, the Lomonosov Ridge, which you can see is that bright line sort of connecting the Eurasian and the North American continents, is an important feature that we'll return to. As the next map will show, Russia, Canada, and Denmark, because of Greenland, all include it in their filings. Fourth and last, just to orient you for the next map, again, the Beaufort and the US are in the upper left there. So we've heard from others that there's a race, and that may be true in terms of technology and other advances, but in terms of the process of delimiting, of showing the extent of the continental shelf, there is not a race. There are rules in Article 76 that all of the states have followed, and eventually it will involve the diplomats again to resolve any overlap. But it's always been science and law and diplomacy working together. As the US executive summary, let me back up. So we've also heard we're not party to this. So great that we followed all the rules, but we are not yet presenting the data that we've published to the Commission on the limits of the continental shelf. And I would say that the 2023 publication walks a very beautiful fine line between, in their decision not to do the filing yet. Because we've not yet presented the submission package to the Commission. As the executive summary that was published in 2023 states, the US will file its submission package with the Commission upon accession to the Convention. The United States is also open to filing its submission package with the Commission as a non-party to the Convention. which would be in keeping with the Commission's mandate. And maybe in the Q&A we can get into a little bit of what the pros and cons were of that approach, but they left both options open. But if you take any message away from my remarks today, let it be this one, that the executive summary and the decades of work that support it are consistent with international law and the global rule-based order for the oceans. How can this be, you might ask? We're not party. Yes, UNCLOS is an integral part of relevant international ocean law and codifies practices followed by states over time, but continental shelf rights are inherent for all coastal states, whether they're party or not, and whether they make a proclamation as to those rights or not. Inherent coastal state rights are affirmed by UNCLOS itself, by the 1958 Convention on the Law of the Sea, to which we are party, as Jim has told us, and by decisions of international courts and tribunals. By publishing that executive summary, the United States protects important national interests now and continues the transparency it has provided since it began U.S. ECS mapping. It also offers an early starting point for whatever scientific and diplomatic discussions will be necessary to reach a final understanding of all coastal states' continental shelf rights in the Arctic. So here's a closer look of what's actually been submitted by the 4 other Arctic Ocean states with shelf in the Arctic and what has been published by us. We've published it but not submitted it to the Commission. The Beaufort Sea, you can see that dotted line that shows the unresolved maritime boundary between Canada and the US. And the dark green and the light green the dark green is the US information and the light green is the Canadian information. And where it's striped, that's where our submissions, our information overlaps. I don't call them claims because they aren't claims. States have the rights to their shelves. So I use the term submission or information. The dark blue line in the middle shows where 3 countries' submissions overlap: Russia, Denmark, Greenland, and Canada. And with the Canadian, which was the most recent submission, the Lomonosov Ridge triple overlap is now, it's about 217,000 square nautical miles. So it's a large area. That little blue circle with the purple arrow pointing to it is all that's left of the potential area beyond national jurisdiction on the shelf. It's gotten much smaller from when we originally started looking at what it might be. And the last thing I'd ask you to trace with me is that it's really, the laser doesn't show on the TV screen, but if you see the 200 nautical mile swath of what looks like water on this map, that up to that 200 nautical miles all the way around that very odd shaped form in the middle, that's 200 nautical miles, up to which point, yes, it's the EEZ, but we're not talking about the water above the EEZ. That's the automatic continental shelf rights that the states have, so they don't have to demonstrate what the geography and morphology are like there. Here's a little different view, a much simpler view. This slide reiterates a key fact already mentioned about continental shelf rights. Within 200 nautical miles, even if a state shelf is only, say, 2 kilometers wide or narrow like Peru or Chile in South America, the state has those rights automatically. But beyond 200 nautical miles, the states must demonstrate how far their shelf extends by following Article 76 about the morphology or shape of the shelf and the thickness of the sediment. I'm really not going to go into the weeds, but we can look at these later if there's still some questions. These go into much more detail about how you find what's called the foot of the slope. And if we go back to this map, the light blue is sort of the upper shelf, and then it drops down to the dark blue, which is the deep ocean seabed. And when we're going through the process of following the Article 76 formula, you need to find the foot of that slope, where those two meet. And that's an important measuring point. And from there, you measure out to the distances that Jim talked about earlier, but you can't go too far. There's a cutoff. And if you look closely at the Bering Sea map, and I can make that the United States publication available to anyone, the Bering Sea map shows where we actually probably could have extended a bit farther, but we used those constraint lines because it would have exceeded those. And this is just a reminder before we turn to the seabed mining that this is a global process going on, and the light blue again indicates roughly continental shelf globally. And state by coastal state, practically every one of them is engaged in the process of defining the outer limits of their respective continental shelves. We've already heard a lot about the Commission on the Limits of the Continental Shelf, the CLCS, as the body who reviews what the states map. It won't review what the US has mapped until the US makes a submission, whether the US does that as a party or a non-party. Here it's critical to note that it is up to every coastal state, it is not up to the Commission to ultimately determine and publish the full extent of its continental shelf, even after receiving recommendations from the CLCS. While a state that bases its outer limits on a recommendation from the Commission strengthens broad recognition of those rights, certainty as to the rights is still years away, at least in the Arctic. Of the 5 states that have published information, to date only Russia has been able to deposit outer limits based on the Commission recommendations, and that's only for part of their submission. Norway, Canada, and Denmark are all either awaiting recommendations or have not yet. I guess they have all now. Canada has deposited its information as well. So the CLCS will likely need 1 or 2 decades to work its way through the 90+ state submissions currently filed and awaiting recommendations before it could even turn to a US submission, should we file one. The CLCS does not decide maritime boundary disputes between states and how to slice up the shelf if 2 or more states' limits overlap. The Commission cannot decide this because the members are scientists, not lawyers and diplomats. But the Commission can decide that more than one state has demonstrated entitlement to the same area. And this may be what happens on the Lomonosov Ridge, which you will recall is an area of significant overlap. And this is where the benefits of being within the convention and being able to be sure, if we were party, that the Commission would give us recommendations, then anybody sitting down with an overlap would have that imprimatur of the Commission, even though the Commission can't then dictate that we have to absolutely accept those recommendations. But it would provide a lot more certainty for any diplomatic negotiations that would then be entered into for determining where's the overlap. And in fact, Norway and Russia, parallel to their ECS mapping, they resolved a 38-year maritime boundary dispute because they knew so much more about where the oil and gas resources were because of the mapping for the shelf. And they did that within the framework of Article 76 mapping, but it was the separate diplomatic process that resolved the maritime boundary. I'm going to speed up a little here because I want us to have plenty of time for discussion. Just before we look at the actual overlaps as filed, it helps to see the ridge, the Lomonosov Ridge as a whole, and to understand that Article 76 requires a coastal state to demonstrate that its shelf is, as Jim said, as you've seen on the screen here, a natural prolongation of the land territory. But is it a natural prolongation from the Eurasian continent, if you follow that little blue line across the Arctic Ocean from Russia? Or is it a natural prolongation from the North American continent, whether Denmark, Greenland, or whether Canada? Or is it all 3, right? They all claim that ridge. And this map, again, to show you one you've seen before, you can see that that's where the biggest potential overlap is in the Arctic. And I put the star in on the North Pole this time because many people have speculated as to what will happen. Who will own the North Pole? Like, it's Canada's identity, right? And some are saying perhaps it will become a zone of peace, agreed to by all three, right? Just the symbolic value of that. It might be gauzy, I don't know. But so we don't know what's going to happen with that. It could, remember I just mentioned that the commission could say they're all entitled. And so that way we would have concrete approval of the science and the underlying data, from the commission, and then that would be even more good material for the diplomats to work with to resolve this particular overlap. So to summarize overlaps and then move on, the CLCS will look at the science. They will not resolve any overlapping claims, but diplomacy and not the commission will resolve those. So now I'm going to shift gears and still leave us time for plenty of discussion to what we've already heard about from many of the preceding speakers, which is seabed mining. Given the President's April 2025 executive order unleashing America's offshore critical minerals and resources, some are asking whether that executive order complements or contradicts the seabed mining provisions established under UNCLOS and how it relates to the Arctic. In the remaining 5 or 6 minutes or so, I can only skim the surface of the topic, but you've already got a bit of background. And so I'll start with my conclusions that seabed mining in the Arctic is a long way off logistically. As we've seen with offshore oil and gas, there are many ice-related and other safety challenges to operating in a dark, cold, remote, dangerous, and largely uncharted environment. If it happens, it would likely be in national waters, that is landward of 200 or even of 12 nautical miles, not on the extended continental shelf. Second, based on the information that is now public from all of the 5 Arctic coastal states, almost no potential international area is left in the Central Arctic Ocean. And this time it's even brighter blue, so you can see it even better on the slide. That's a very small area for the Seabed Authority to manage. So back to the Seabed Authority. You've heard, whoops, that logo never comes through. It's a little beautiful scale on scales of justice on an ocean blue background is the sign of the International Seabed Authority. The Seabed Authority administers the area, the seabed, the ocean floor, and the subsoil beyond national jurisdiction. It was established in 1996 when the agreement relating to the implementation, not of the whole convention, but just of Part 11. The agreement relates to the implementation of Part 11 of UNCLOS. And that's entered into force in 96. And it was necessary, as we've heard, that agreement because many developed nations, including the US, strongly objected to the original Part 11 seabed mining provisions in UNCLOS. The US led the negotiations of the agreement to improve Part 11, and the United States signed, but never ratified it. And we've heard from almost everybody who's preceded me that the ISA has been active for a very long time, for some 30 years, and until the April executive order, the US has attended its meetings as an observer, actively participating where it can. The ISA has issued some 30 exploration contracts, mostly in the Clarion-Clipperton zone, which is south of and between Hawaii and the Baja Peninsula, roughly. In its 30 years, and here Stephen Groves has some points. The ISA, they've done some things. They've established some protective zones for sensitive areas, and they've worked toward best practices. But since 2019, they've been unable to reach an agreement on a formal mining code. So no mining is taking place. Much remains unknown about how what amounts to essentially vacuuming up the seafloor will affect ecosystems, species, and ocean health. This map shows you the location of the 30-plus ISA exploration contracts. Those are in blue. The protected areas are in green. And the US license areas are in red. What are those doing there, you might ask? They were established under DSHMRA, as we've already heard. There is the domestic law, the Deep Sea Hard Minerals Resources Act. And it was drawing new attention because it's mentioned in that April 2025 executive order about seabed minerals. Looking at DSHMRA, the Deep Sea Hard Mineral Resources Act, it was enacted in 1980, so shortly before the Law of the Sea came into, was signed. And it was enacted when the US objections to Part 11 of UNCLOS had not been addressed or weren't being addressed. DSHMRA established a kind of shadow or holding pattern for US exploration in what is otherwise known as the area until such time as US concerns with UNCLOS Part 11 could be resolved and the US could join the treaty. NOAA did issue those 4 licenses in 1984, 2 of which have been abandoned, and the other 2 are still held by Lockheed Martin. And to all appearances, Lockheed Martin they're doing things like resolving or they're applying every regular session to NOAA to extend the contracts, but they've actually sold off, Lockheed Martin has sold off its deep sea mining provisions, or its leases, excuse me, back up. It's sold off its, not the rights that it has, but its division that deals with deep seabed mining. So it's not entirely clear what they'll do with these leases. People are watching with interest to see whether they'll try to reactivate them. I think that we've heard of the Minerals Corporation, TMC. TMC, not TSC, has applied for new licenses and permits with NOAA. And the new unilateral permitting by the US would set up a competing regime to the International Seabed Authority. And there are very differing, there's a lot of ink spilled on this. Some are saying that the US could not possibly act under the executive order. It would be illegal and contrary to UNCLOS. I think the more convincing argument is that Part 11 of UNCLOS has not entered into what we call customary law. It's so, that we don't have any active mining under it yet, so I think it's more likely that the United States could successfully argue that it would not be in violation of international law for the US to go ahead and issue those new permits. So it's not a decided issue. I'm not an expert on the area, but it does raise some interesting questions. I think with that, I'm going to turn it over we still have about 25 minutes, 23 minutes for questions. I've made these points before. The United States limits are now clear to the world. Diplomatic processes should work to resolve any overlaps in the Arctic. I believe firmly that joining UNCLOS will strengthen our assertion of the rights and especially strengthen international respect for the rights in the extended continental shelf. And if we could actually submit something to the Commission on the Limits of the Continental Shelf as a party, that would be a much safer approach than submitting it now, as has been suggested, because states would raise objections to us trying to claim special privileges by not being a party. And there is no deep seabed mining off of Alaska in the foreseeable future, but beyond that, who knows? So I do have sources on the slides. I don't know if these will be made available to attendees, but if you're interested in my sources, I can provide those. But otherwise, thank you. And what are your questions?
So thanks, Betsy. Phil Lawler again. Maybe if I might, 2 quick questions. The first is a quickie. And that is, you talked about, and this will show immediately my relative ignorance of UNCLOS, but the mapping that you did, at least for the Arctic, or maybe for the whole US, in general, like how much further did that take the limit of rights beyond the 200 miles? I'm looking for, is it like another 100 or 500 miles or something?
I can't answer that in terms of actual distance, but you can see here the dark green areas I should be able to. I don't have the count in Troy, maybe.
Watching the top left, like
Yeah,
11 o'clock.
that's, so
Okay.
it, up to 200 nautical miles is the light blue swath.
Right.
And we do have figures here that talk about, I mean, I don't know exactly how far
I see.
out it extends, but the
Okay.
measurements are, in the Arctic, it's about 520,000 square kilometers. That's about 2 times the size of California. So that's just in the Arctic alone.
Right.
That green, you can see the purple on the map here is what was the green overlap on the
I see.
map of the whole Arctic Ocean.
I don't know that it's really important, but it's clear it's a lot of area, and it looks like from a rough gauge, I mean, in some places, it's more than double that 200 miles limit.
Oh,
I
yes,
think, yeah.
easily.
I see.
Yeah.
Okay. My other question, and I'm not sure if you can answer this, because there was such a long line with Steve Close, but he mentioned, and maybe this relates to your area, maybe not, but if it does, he mentioned how, for example, the U.S. Navy had come to Heritage Foundation asking for their support to ratify or bring this closer to ratification, and he offered his reasons and arguments against it. But do you know why the Navy was what they were focused on? What was their argument or their focus? Was it to do with what you're talking about?
I can speak only to what I have heard other representatives of the Navy and the Coast Guard say is often the first, well, especially the Coast Guard, the first question I get is, why are you not party? It would be so much easier if you were party. And I won't speak for the Coast Guard, but have heard that because I get this question a lot. It is, we're operating under customary international law status with all of, I mean, it's the rules of freedom of navigation and others that are at passage for warships, et cetera. Those are established by customary international law, but the international community has codified those in the Law of the Sea Convention, and it's just sort of a big question mark hanging over practical operations, naval operations, Coast Guard operations. Why aren't you party? It casts some doubt on our commitment, and it casts some doubt on our willingness to follow those rules. On the panel tonight, there are 2 panels where we can go into this in a lot more detail, and you will actually hear from people with that experience.
Thanks very much, Betsy. I learned a lot. And I may just respond to what you just said. The logical argument is if we consider everything as customary international law, then logically we should join the convention. And that argument has been made by a number of other countries. But there's a lot that proceeds from that. For example, a recent surge towards a moratorium on seabed development, joined just in the last couple of months by France and Spain and a couple of other countries. I think there are about 37 countries now that want to establish a moratorium. And that is a complication on this reliance on customary international law. But I stepped up to I joined the pack in front of the microphone, specifically to ask why it is that the Deep Sea Bed Mining Act preceded the conclusion of UNCLOS. You had the U.S. delegation very actively involved in the UNCLOS negotiations, and meanwhile, Congress was enacting this act that not only would have been known to the U.S. delegation, but also to other delegations. And I tried to find this out myself, and I didn't find much to explain why that didn't have more of an effect on the original version of Part 11. Surely it seemed to be an open invitation to deep sea bed mining that contradicted the whole fairly elaborate regime that was set up under Part 11. I kind of wondered how that fit together in those 2 or 3 years between the enactment of the legislation and the conclusion of UNCLOS.
You, with your question, have provided more information than I can. I have not looked yet at the legislative history,
Well,
and
I found very little,
yeah.
and maybe I should look deeper, but it puzzled me, particularly as a matter of consistency and clarity within the position of the U.S. government during that period of time when we had, on the one hand, this open invitation to seabed mining, and then UNCLOS, maybe helping explain why, well, maybe we thought that the delegations to UNCLOS had paid insufficient attention to our Deep Sea Bed Mining Act, and it was almost retaliation to refuse to sign the entire UNCLOS because of Part 11.
yeah, I would
Out of
be
some sort of
speculating.
spite, in
Yeah.
a way, that we had gone ahead with this act that really was contradicting what was being negotiated, leading just 2 years later to
Yeah, I guess I'm not sure it did contradict. There were so many changes made to Part 11
Yeah.
as it was being finalized, and maybe they were putting it out there as a marker or an example of what they would view as a reasonable regime for seabed mining. And I would imagine, I mean, that was all of the rage was polymetallic nodules, and celebrity, famous people were investing in figuring out ways to how can we get to these and mine them.
There was great excitement at that time.
It was great excitement, and so perhaps it was just that pressure and trying to be responsive within the U.S. legislature to that interest and showing what one regime could look like. I think there's a research paper there for one of your
Maybe
students.
so. Okay. Then if I can hold the floor just for one more minute. To what extent did the President's executive order on April 24th speak adequately to the distinction between seabed mining within the exclusive economic zone, which is already being done, as a matter of exploitation, in addition to the exploration by Sweden and Norway, and I think the Cook Islands, which seem to be involved in all of this, are just going ahead with that within their own EEZ, which is something that could be done. It would be under the supervision of the Department of Interior Board of Ocean Energy Management, whereas everything beyond the EEZ would be managed under NOAA, I think. There's that distinction. So we do make that big distinction. I'm just wondering, is there anything in the President's order that spoke to that distinction?
It's not a terribly long order. You can find it on the White House homepage, and
I
it
didn't
doesn't
find
really.
anything.
There's nothing in there that goes into that level of detail. What I do understand from people who studied this more than I have are that the company that is seeking, so it's now a U.S. subsidiary of the Canadian company, TSC, they lobbied
The
very
metals
heavily
company.
for the inclusion of that second point.
Yeah, but they're a step ahead of where they should be
Right.
prior to a mining code and regulations for
Right,
exploitation.
and as
But I would have thought the President, in all, may I say, his brashness at times, would have said something about we're going to go ahead with deep seabed mining within the EEZ.
You've
There's
seen the
nothing
language
there.
of the.
It's just puzzling.
But I think what's
wonder-
really important is who in the investing world would want to sink a lot of money into something that you don't have the technology for, you don't really have rules in place there will be other constraints that might prevent it from happening.
Yeah, exactly. Thank you very much.
No, thanks for the questions.
Betsy, I was particularly intrigued with your slide of the worldwide efforts here to demarc boundaries. So this is off the wall. How is Antarctica dealt with in terms, as I recall, the governing regime is mid-1950s for Antarctica, but again, no state claims control. But
Right.
it is faced with the same extended continental shelf issues. Who deals with that?
So if you look at the submission, say, of Australia, they acknowledge the existence of the Antarctic Treaty, whereby territorial claims are suspended. That's one of the key elements of the Antarctic Treaty. And this gets to our larger discussion later this evening of the benefit of being in an international system rather than outside of it and not being a party. There, the Antarctic Treaty System is starting to see some efforts to erode that provision precisely because there are resources there. But because the United States is party to that, it is able to at least fend those off. We don't know how long that will last. But right now, the claims are, if you will, the submissions are acknowledging what the scientific data is without extending their shelves that far.
Yeah, Betsy, so if we don't apply for the extended outer continental shelf, can anybody else go in there? So we've seen, the Chinese icebreakers have spent so much time around there. We've tracked them. Could they come in if we say, well, we're just going to have a free-for-all like was suggested by the Speaker Graves? Could the Chinese go in and start oil drilling on the continental shelf if we haven't applied for it? And then my other question is, what is the significance of sedimentation? I couldn't get how that defines anything. I couldn't understand that.
Okay. I'll answer them in order. In theory, China could go into the area that the U.S. has now published they could go into the area within the extent of that shelf. They would be ill-advised to do so. Just the practical response from the United States would be either diplomatic or hopefully not military. Our rights are inherent in the continental shelf, and other states have to recognize them. And the United States is hoping that by actually providing more information in its publication than many states do in what they submit to the commission, that states can go in and look and see. They can read each one of those data points if they have a big enough computer and a dedicated enough team, and they can test the science and challenge it themselves. We've put all of that data out there publicly. So it's to me, it's an imaginable scenario, but highly unlikely, and the United States would respond and within their rights, that this is our continental shelf. And we only can determine who gets to access it and under what terms. As for the sedimentation, one way to tell whether something is a natural prolongation of the shelf or whether it's just the deep seabed is how much sediment is at that point where the slope comes down to the ocean floor. And I won't go into any more detail than that because I am a law professor and not a geomorphologist. But would be happy to show you a lot of pretty pictures of sediment piles. Okay. Other questions? Thank you.
That was Dr. Betsy Baker discussing the extended continental shelf. It was recorded October 10th, 2025 at KTOO on the unceded territories of the Occoquan on Tlingit Ani as part of the 2025 Juneau World Affairs Forum, Unratified, the International Law of the Sea Treaties and their potential for protecting Arctic resources and cultures. Produced by the Juneau World Affairs Council and Veterans for Peace Chapter 100 in collaboration with KTOO. With support from Core Alaska Kensington Mine, Wastman and Associates, Ramada Inn,